शशांक, हेलो शशांक, सुन पा रहे हो तुम?
यस सर।
एज आई टोल्ड यू, जब सभी जजेस ज्वाइन कर लेते हैं
ओके
बाद हम लोग पार्टिसिपेंट को लेंगे। अभी जो आ रहे हैं उनको वेटिंग रूम में आने दो, ठीक है?
ओके मैम। ओके सर, तो मेरे को बता देना कि कौन 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 जज है, तो मैं
ओके।
उनको अंदर ले लूंगा। अभी कोई अभिषेक
राहुल
यादव
कुमार
बता
को
रहा है।
कोस्ट, राहुल कुमार को कोस्ट बता दो, वो मैं लिस्ट देख रहा, मैं तुम्हें बोलूंगा जिसको लेना है। तो राहुल कुमार को कोस्ट बता दो।
ओके ओके सर, वेट अ सेकेंड। राहुल कुमार को
और अशोक कुमार, 1 मिनट, राहुल कुमार ओनली।
मैंने राहुल कुमार को कोहुस बना दिया।
और यूट्यूब लाइव कौन कर रहा है? शशांक, तुम यूट्यूब लाइव कर रहे हो?
नो सर, मैं नहीं कर रहा हूँ।
ओके। हिरांशी मेम इज देयर?
Press.
बोलो बोलो, जल्दी बोलो, जल्दी बोलो।
नमस्कार जस्टिस शाह।
नमस्कार ब्रदर।
हाँ
How are
नमस्कार
you?
सर, नमस्कार।
फाइन।
बिल्कुल ठीक है सर।
यू आर इन दिल्ली?
हाँ सर,
अब ठीक है?
बिल्कुल सर।
चलो, बहुत अच्छी बात है।
आप देखिए, अच्छा है ना, नरक में रहते हुए भी अच्छे हैं।
जस्टिस शाह has also come. Good evening.
हाँ
डॉक्टर साहब नमस्कार।
नमस्कार सर, नमस्कार।
नमस्कार।
सिंघवी साहब नमस्कार।
हाँ नमस्कार, नमस्कार सर, नमस्कार।
सॉरी सर, आई एम नॉट एबल टू हियर यू।
हिरांशी भी आ गई है। How are you,
जस्टिस
हिरांशी?
ठक्कर साहब को तो सुनाई दे रही है आवाज।
फाइन सर।
बोलिए
नमस्ते
बोलिए सर। हाँ
राजनीति
नहीं,
मंच।
आपकी आवाज
हिरांशी,
मैं
आई एम
तो
नॉट एबल टू हियर अदर्स। हिरांशी,
हेलो सर, एम आई ऑडिबल टू यू?
You are very much audible, at least to me.
Sir, we will start session after 3-4 minutes.
आप जस्टिस
एम
शाह
आई
से,
शाह सर, एम आई ऑडिबल टू यू?
जस्टिस शाह?
उनके कनेक्शन में कोई प्रॉब्लम है हिरांशी जी?
हाँ ब्रदर, you can hear me, no?
हाँ हाँ,
हाँ वाह वहाँ। ब्रदर शाह, can you now hear us? मुकेश भाई,
नहीं लग रहा है साहब।
there is some problem somewhere.
I will call Justice M.R. Shah sir and see what is the problem to resolve.
Yes,
Can we
yes,
try?
please do it.
Yes.
Exactly, हाँ, so that he can join. और सर, और बताइए।
बस ठीक चल रहा है साहब।
गुड इवनिंग सर।
हाँ माइक्रोफोन
ब्रदर शाह, can you hear now?
आपण म्यूट हाँ એટલે ऑडियो અને वीडियो हाँ हाँ
We can hear him, no brother Singhvi?
हाँ हाँ, बिल्कुल बिल्कुल।
हाँ, वो तो ऑडिबल है। I don't know how.
Good evening, sir.
Very good evening.
Good evening, Honorable Sir.
નમસ્કાર ભૈયા।
તમે મને મારું તમને સંભળાય છે બધાને?
Yes, now we can hear
हाँ
you.
मुकेश जी आपकी
ઓકે
आवाज
કઈ
अब
વાંધો
सुनाई
નહીં.
दे रही
હું
है
બી તમને સાંભળું જ છું હવે. હા
Yes.
હા
Now you are very much audible.
मुकेश जी आपको हमारी आवाज सुनाई दे रही है?
Oh. Brother Shah, can you hear us? No, there it is one-sided. Hiranshi, there is some problem.
Jitayu, kindly call the sir. I think so sir is not able to hear us.
Yes,
We
I-
can
because we can hear
the
him.
sir.
Hmm.
हाँ. Jitayu,
I have
kindly call.
yes, I have talked with sir. Yeah, and now probably he will be able to hear us.
Very good. Brother Shah, can you hear us now?
नहीं है सब अभी.
हाँ नहीं है.
He's trying to reconnect.
हाँ.
Yes.
Brother Shah, can you hear us?
उनके एक्सप्रेशन से लग रहा है कि वो सुन नहीं पा रहे हैं.
हाँ नहीं सुन पा रहे हैं हम उसको सुन पा रहे हैं.
Sir, can you please rejoin?
Jitayu, kindly call the sir and tell them to rejoin. I think so some technical glitch from sirs and network.
जस्टिस शाह दिल्ली में है या अहमदाबाद में?
In Ahmedabad, sir.
He is
अच्छा.
in Ahmedabad. Today there was function also, but probably he is unable to hear us. That is why he is unable to answer.
He must be more familiar, sir. He is the youngest amongst us.
Correct.
હાજી હાજી ઓકે ઓકે હું મારું ટ્રાય કરું છું. ડોન્ટ વરી. ત્યાં સુધી ચાલુ કરી દો તમે. હા હા યુ સ્ટાર્ટ. હા હું બીજા વોઇસ પર બીજા ડિવાઇસ પર જઉં છું. હા હા
ના એ પેલું કરવું પડશે.
जस्टिस शाह अब सुन सकते हैं आप हमारे को?
I don't think so.
Actually, sir told us that he is able to hear us, but we cannot hear his voice.
No, we can hear him when earlier, at least before 2 minutes, but probably he is unable. Brother Shah, can you hear us? No, probably no.
Sir, he has requested us to start.
Jitayu, you can start in 1 minute.
Recording in progress.
Justice Thakker and myself have one bad habit of being punctual to the time.
Judicial discipline, no?
Sir, it's not a bad habit to be punctual.
नहीं आपके और मेरे जमाने में तो हम क्लास में भी लेट नहीं जा सकते थे.
As being student, we should also be punctual.
रोहित सिंह का ये
Justice,
मैसेज है कि हम लोग हिंदी में बात करें.
मैं तो थोड़ा जानता हूँ.
सर आपका
No
हिंदी
problem.
हमारा गुजराती हिंदी होता है.
नमस्कार नमस्कार शाह साहब.
नमस्कार सर नमस्कार. हाँ जी.
Sir, now you are perfectly audible.
Brother Shah
हाँ
is
या
over
या
there.
या.
He's
So-
there now. Brother, now can you hear us?
हाँ, I am hearing now. हाँ.
Very good. We can also hear you now.
Very good, sir. That is the most thing. हाँ.
So
Namaste.
Hiranshi ma'am and Justice Singhvi sir and Justice Ashok Kumar Joshi sir and MR Shah sir, can we start now?
Yeah,
With
yeah,
your
sir.
permission.
Yes, you can.
Thank you. Good evening to one and all present here. I, Jayant Agrawal, as the coordinator of this event, welcome you all on behalf of Sambhav Initiative. Today, we are privileged and honored to have with us Honorable Justice C.K. Thakker, sir, former Judge, Supreme Court of India, and Patron-in-Chief of Sambhav Initiative, and Honorable G.S. Singhvi, sir, former Judge, Supreme Court of India, and Honorable Justice M.R. Shah, sir, former Judge, Supreme Court of India, and Patron of Sambhav Initiative. And our another special guest is the present Solicitor General of India, Honorable Tushar Mehta, sir, at inaugural ceremony of second edition of We the People of India Week 2023 and session on Ek Samvidhan organized by Sambhav Initiative, which is working towards ADR, free legal aid, mental health, and legal literacy. Before starting of the session, please follow some seminar etiquettes. I request all participate their microphone on mute mode during the session. In case you have any question, then please raise your hand and use chat box. Now, I would like to invite Mr. Jitayu Yarnik, member, Administrative Department, and coordinator of this event, to introduce Ms. Hiranshi Shah, founder of Sambhav Initiative, who may deliver welcome speech.
Hiranshi Shah is a distinguished professional in the alternative dispute resolution with an illustrious background. She is an associate member of the Chartered Institute of Arbitrator in United Kingdom and a member youngest certified mediator in Gujarat, certified by the Ministry of Corporate Affairs, Government of India. She is also the young member of Singapore International Arbitration Center and the London Court of International Arbitration, International Council for Commercial Arbitration. Furthermore, Hiranshi Shah ma'am has extended her expertise to being a respected judge in numerous international and national ADR competitions and has been invited as a chief guest for Asia's Top 100 Influential Women Award. Her contribution also encompasses serving as a conciliator in pre-litigation and pending cases for various district legal services. It is our pleasure to have her between us with her strong vision of transforming society by walking on the path of the Constitution of India. Now I would like to invite Ms. Hiranshi Shah for the welcoming speech.
Thank you, Jitayu, for your kind words. On behalf of the Sambhav Initiative, I'm honored to firstly welcome you, our own patron and chief, Justice C.K. Thakker, sir, former Judge, Supreme Court of India, and the patron of Sambhav Initiative, Justice M.R. Shah, sir, former Judge of Supreme Court of India, from whose invaluable support and envisioning and directing not only the week but overall vision of the Sambhav Initiative. So, as with their support only, as when Justice Justice K.G. Balakrishnan sir inaugurated the Sambhav Initiative 2 years ago, in the COVID time, we were only working Vadodara District Court, but now with the invaluable support, guidance, and advice from them, currently we are working with the Ministry of Road and Transport, Government of India, and with many district courts in Gujarat and also with the Gujarat Police. So first, I welcome you, both of you, sir. I'm also honored to welcome Justice G.S. Singhvi, sir, former Judge of Supreme Court of India, and Shri Tushar Mehta, sir, Solicitor General of India, for in this session. I'm also welcoming other esteemed officials, board members of Sambhav Initiative, delegates of Sambhav Initiative, and our esteemed attendees for this inauguration ceremony of second edition of the We the People of India Week 2023, and also with that we have a session on Ek Samvidhan or Ek Hum. If I briefly say about the People of India Week, is a week-long celebration that starts under the Lakshya movement of the Sambhav initiative, which aim to celebrate our constitutional values and the principle. With this year, our theme is fundamental rights. So during which we will going to celebrate our fundamental rights continuously for the 7 days. In order to celebrate right to equality, we had organized the session on Ek Samvidhan or Ek Hum with today's esteemed dignitaries, and on second day for right to freedom, talk show on Swatantrata ke Samvad and LGBTQ rights. We are planned with Prince Madhvendra Singh, who is a crown prince of Rajpipla. We on the third day for the celebrate the right against exploitation, we are planned Ek Buland Awaz, a public lecture on role of police in protecting individuals from exploitation with Shri Anil Pratham, IPS, Director General of Police, Reform, Government of Gujarat. For on fourth day to celebrate freedom of religion, we are scheduled the online national debate competition on Dharma ki Paribhasha. Then to celebrate fifth day, that is culture and educational right, we are scheduled the online national quiz competition on Sanskruti se Sarva Shiksha Tak. And not last but not least, to celebrate the sixth day, that right to constitutional remedies, we are organize online symposium on Ek Kadam Nyay Ki Aur on right to constitutional remedies with Justice S.G. Anand, former judge of High Court of Punjab and Haryana, and with Justice Ashok Kumar Joshi, former judge of High Court of Gujarat. And this by this week, we're going to end on 7th day, that is on Samvidhan Pe Charcha. Thank you everyone to be join in this inauguration ceremony, and also thank you to all our dignitaries, patron, and guest of the today. Thank you, sir.
Thank you very much, ma'am, for the welcome speech. Now, I would like to invite Dr. Gururaj, Editing Department member of Sambhav Initiative and the Assistant Professor of Nirma University, to introduce Honorable Justice C.K. Thakker, former Judge of Supreme Court of India and Patron-in-Chief of Sambhav Initiative, who may deliver opening remarks for today's event. Over to you, Dr. Gururaj.
Thank you, Jitayu. I am honored to introduce Honorable Justice C.K. Thakker, sir. He is a retired judge of the Supreme Court of India. He was born on November 10, 1943 in Mandar near Porbandar in Gujarat, India. After taking primary education at Mandar and Madhavpur, Justice Thakker graduated from a college in Junagadh and obtained a Bachelor's of Law degree from a law college in Jamnagar. He also obtained a Master's of Law from the Gujarat University and began practicing from 1968 in the High Court of Gujarat. He was elevated to become a judge of the High Court of Gujarat on 21st June 1990. He was further promoted to the Chief Justice of the High Court of Himachal Pradesh, Shimla, on 5th May 2000, and transferred as the Chief Justice of High Court of the Judicature at Mumbai on 31st December 2001. He was appointed as a judge of the Supreme Court of India on 7th June 2004. He was also acting the governor of the state of Maharashtra from July to October 2002. And Justice Thakker has written several law books, such as the Lectures on Administrative Law and the Code on Civil Procedure, which still remains a standard textbook for the law students in India for more than 25 years. We welcome you, sir, and we are honored to have you, sir.
Yes.
We
Yes.
would request sir to continue.
Okay. Brother Singhvi, Brother Emma Shah, and my friends, I am extremely happy to be here, to be with you today here. I tell you, there may be subjective approach also, और जैसे सिंघवी साहब ने कहा तो मैं थोड़ा हिंदी में भी कहूंगा. Excuse me for my Hindi, if there are some errors. But I may say only one thing, that वो subjective element आ जाता है. But I was student of political science, तो मैंने तो जब भी जॉन बोर्डिन, बेंथम and others पढ़े, तो हमने तो यही पढ़ा था कि law is a command coming from upwards going to downwards. Downwards people they are bound by law. The lawmaker is not bound by law. King can do no wrong. Dictator, king, queen, they are above law. So for the first time when I attended, I distinctly recollect lecture in Constitution in Jamnagar Law College. So first lecture was of Constitution. और उसमें बताया कि we the people of India. I was so much happy कि भाई ये तो हमारा कॉन्स्टिट्यूशन है, हमने हमें दिया है और ये जो है सब कुछ वो हमारा है. फिर कॉन्स्टिट्यूशन पढ़ा, कितनी केयर उन लोगों ने ली है कि फॉर इंस्टेंस आई में से फंडामेंटल राइट्स पार्ट 3, डायरेक्टिव प्रिंसिपल्स पार्ट 4, समथिंग इज टू बी डन व्हिच मस्ट बी डन contained in part 3, some obligations on the part of state may not be justiciable. उसके लिए आप कोर्ट में नहीं जा सकते, लेकिन उन लोगों ने ये सोचा और ये दिया. सुप्रीम कोर्ट, हाई कोर्ट्स, एग्जीक्यूटिव, सेंट्रल गवर्नमेंट, स्टेट गवर्नमेंट, पार्लियामेंट, स्टेट लेजिस्लेचर. सो सेपरेशन ऑफ प्रिंसिपल्स, जो सेपरेशन ऑफ पावर्स का प्रिंसिपल है वो भी किया. एंड लुक एट क्या क्या उन लोगों ने सोचा. लो स्टूडेंट्स या तो लो में थोड़ा सा जानने वाले ये जानते होंगे कि wherever there is right there is remedy and there cannot be any right without remedy. तो अगर रेमेडी नहीं प्रोवाइड की है तो भी अगर राइट है तो रेमेडी मिलेगी. बट उन लोगों ने आर्टिकल 32 रखा और 32 पार्ट 3 में रखा. A person for enforcement of fundamental rights can directly approach the Supreme Court. And there are also judgments, you may be knowing, that it is not only the right but the duty of the Supreme Court to grant relief if prima facie case has been made out for infringement of fundamental right. तो 32 मैं अपने आप से पूछता हूँ एक सवाल कि सपोज 32 नहीं है तो क्या आप कोर्ट में नहीं जा सकते? जा सकते हैं. फिर भी उन लोगों ने किया, जुडिशियल पावर्स भी दिया, सेवरल जजमेंट्स भी आ गए. मैं उस सब में नहीं जाऊंगा, गोलकनाथ एंड बेसिक स्ट्रक्चर, केशवानंद भारती. बट देर आर सर्टेन बेसिक स्ट्रक्चर, बेसिक प्रिंसिपल्स, वो हम छोड़ भी नहीं सकते. तो उसमें ये सब आया. तो मेरा तो ये मानना है कि ये जो कॉन्स्टिट्यूशन डे है वो मनाया जाए. मेरा ख्याल ऐसा है, और 2 दिन पहले मैं टॉक देने, लाइव टॉक देने वहां गया था सेंटर में, ये टीवी सेंटर में. तो मैंने कहा था कि मेरे ख्याल से 50 साल जब कॉन्स्टिट्यूशन के पूरे हुए तो उस समय गवर्नमेंट पब्लिकेशन, गवर्नमेंट ने ही एक कॉन्स्टिट्यूशन की बुक बाहर रखी थी. कितनी प्राइस थी वो मुझे आज याद नहीं है, बट बहुत कम प्राइस थी. बट मैं तो ये कहूंगा कि हर व्यक्ति को कॉन्स्टिट्यूशन की एक कॉपी जो थोड़ा सा जानता है उसको रखनी चाहिए. ये प्रिंसिपल समझना चाहिए और हमें उसका अमल करना चाहिए. क्योंकि सिर्फ फंडामेंटल राइट्स दिए हैं उसकी ओर ही देखो, डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी के ऊपर मत देखो, या तो फंडामेंटल ड्यूटीज जो चैप्टर 8 हुआ है उसको भूल जाए. ये भी नहीं, ठीक नहीं है. ये तो एक सिक्का की 2 बाजू है. एक बाजू एक और राइट है, दूसरी ओर ड्यूटीज है. तो हम सब ध्यान में रखें और उसका पालन करें. थैंक यू वेरी मच.
Thank you very much, sir, for the opening remarks. Now I would like to again invite Dr. Gururaj to introduce Honorable Justice G.S. Singhvi, former Judge, Supreme Court of India, who may enlighten us with his speech. Over to you, Dr. Gururaj.
Thank you. I am honored to introduce Honorable Justice G.S. Singhvi, sir. He is a retired judge of the Supreme Court of India. He was born at Jodhpur on 12th December 1948 He graduated in 1968 from Jodhpur University and earned a Bachelor of Law degree in 1971 from Rajasthan University with a gold medal. Sir joined the legal profession on 28th July 1971 under Shri Marudhar Mridul and practiced in Rajasthan High Court at Jodhpur till June 1977 and shifted to Jaipur on creation of High Court bench at Jaipur. He was elevated to the bar to the bench of Rajasthan High Court on 20th July 1990. He was transferred to the Punjab and Haryana High Court on 28th April 1994 and thereafter as judge of the Gujarat High Court on 28th February 2005. He was sworn in as the Chief Justice of the High Court of Andhra Pradesh on 27th November 2005. He elevated to the Supreme Court and assumed office on 12th November 2007 and retired on 12th December 2013. Some of his notable judgments include the 2G Spectrum case, Vehicle Beacon Lights Issue case, NAS Foundation case, and the 2011 Greater Noida Industrial Development Authority case. We are honored to have you here, sir. Over to you, Justice G.S. Singhvi, sir.
Thank you all. And please pardon me if I am unable to give full speech in Hindi. I can share with you something about Hindi before I start my speech. While I was working in Punjab and Haryana High Court as a judge, I used to go to Punjab University for giving lecture to the law faculty. There the students were regular students as well as those in service, means who were already serving the government and various departments, including corporations, etc. On a particular day, I gave my speech in Hindi for about 45 minutes and then in English in another 45 minutes. After giving the speech, I forgot everything. About 6 months thereafter, I was traveling to Jalandhar for giving lecture in another university. And in my car, there was a small magazine by LIC. I thought, what is the use of this magazine to me? I opened the pages and then there was a reference to myself. And there was an article by one of the employees of LIC who was a student of law in Punjab University. And that was interesting. He said that when Justice Singhvi came and spoke in Hindi, we thought that his English is poor and therefore he is not able to speak in English. I was quite amused. And the next sentence was that once he spoke in English, then all our misgivings were removed. Unfortunately, in our country, despite passage of 75 years, we still continue to speak in the language which does not belong to us. And I have no hesitation to say that the language which we use in the courts, at least in the superior court, that is the High Courts and the Supreme Court, is not the language of the people. Whether it is Rajasthan, Gujarat, Maharashtra, Punjab, Haryana, Kashmir, or go to Tamil Nadu, go to Karnataka, it is not the language of the people. That is the tragedy in our country, that is still we continue to use the same language which was used for 200 years by the persons who illegally ruled us. Anyway, my elder brother Justice Thakker has already given a broad outline of the Constitution. But one thing I would like all students of law who read the Constitution, perhaps it is taught in the first year of their law course, to read the preamble carefully. If some of the students have the book, I would like to request them to take the book. The preamble says, "We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic." Word socialist and secular were added in 1977. But this declaration is not enough. We had made a promise to ourselves. Read the last line of the preamble before we come to other parts. And to secure to all its citizens. That was the pledge taken by the people of the country, and that is the pledge taken by each one of us who are born in this great nation. What? The pledge was to secure to all its citizens. First word is justice. And that too clubbed with the word social, economic, and political. Then comes liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote them among all fraternity, assuring the dignity of individuals and the unity and integrity of nation. I do not know how many professors have laid emphasis on the second part of the opening 4 sentences of the preamble, and to secure to all its citizens. Why? And you must always make a query to yourself. Why the word social was used first with the word justice? What was the reason? And we nowadays usually take the term scheduled caste, scheduled tribe, backward classes, as if these people belong to an inferior category. Nobody takes pain to explain why they are called scheduled castes. Is that a particular number of castes have been put in a schedule to the constitution. Why a particular person is called scheduled tribe? Because those tribes are put in a schedule to the constitution. Why they are called backward classes? Because they are put in a schedule to the constitution. Otherwise, there is no difference. Then we come to, as Justice Thakker has rightly laid emphasis on, part 3 of the constitution. But despite my senior brother saying that the directive principles of state policy are not enforceable, I have a different view. If you read various articles of part 3, there are some injunctions in negative form, some in positive form. But part 4 is the soul of the constitution. Please open article 38. Please open article 39. Please open article 40. I will read only one line of article 38, and you can read all articles from 38 to 50. What does it say? Article 38 says, the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may, a social order in which, again, justice, social, economic, and political shall inform all the institutions of the national life. Emphasis by the framers of the constitution, 200 visionaries sat for 3 years. Of course, 44 of them belonging to Muslim League walked out in the midst. They worked for 3 years tirelessly to make this constitution. They knew what are going to be the problems of this independent nation. Therefore, while making that the court will not be able to enforce, made these things obligatory for the state. Kindly read article 38 to 50 and you will find everything is the state shall do this, state shall do this, state shall do this. And then again the visionaries of the parliament thought it proper to introduce part 4A of the constitution, which now says that it shall be the duty of the citizens. Again, word is shall. So when you read the constitution, my request to all the students would be, please read part 3, part 4 and part 4A together. Then you will be able to understand the synthesis of the constitution. Then you will be able to understand what the crux of the Constitution is. One thing more I would like to add before going to other aspect of this. I do not know how many of you have been asked to read the framing of the Constitution by B. Shiva Rao, the great learned author, and volume 5 of that, there are 5 volumes of that work done by Dr. Shiva Shankar Rao. There is a letter written by the great visionary of this country who was the president of the Constituent Assembly, Dr. Rajendra Prasad. I wish all the students of law, all the students of political science, and all members of the judiciary read that letter of Dr. Rajendra Prasad. He said many things in that. When you get time, you read it. But one thing most poignant he said, he was addressing the bureaucrats and men in uniform, that is the army people or police people. I am only translating, it is a letter written in Hindi, printed on lithograph. The same letter has been printed with corrections carried out by Dr. Rajendra Prasad in his own handwriting. He says, all these years you have served the masters, that is the Britishers, and you thought that you are the masters of the people, addressing the bureaucracy and the army. But now that we have become an independent nation, we must change our mindset, and all of you should become this is the expression which is most important, which we have unfortunately not adopted. Servants of the people, Janta ke sevak. There is a world of difference between the expression public servant and servants of the people. Alas, all our public representative, all our judges, all our bureaucrats had thought that we are servants of the people. We have been given this duty to serve the people. Now, another aspect, I will make a little digression. The objective of social justice, economic justice, and political justice is important. But what is more important is the dignity of individual. Unfortunately, in 75 years, we have not been able to achieve that goal of ensuring dignity of individual. All of you are aware that when the Constitution was enforced, education was not made compulsory. It took us 60 years to amend the Constitution and make the education compulsory up to the class 10. And it took another 4 years to the state apparatus to enforce that. I do not know. I am living in Delhi, therefore I am oblivious of what happens at the grassroots level, whether still education is compulsory for each and every child up to class 10 and compulsory. If we had introduced this provision in the Constitution in 1950, India would have been different. No doubt about it. Another facet of the dignity, we did not bother about our healthcare system. As a student of law, as a lawyer, and a judge, even after my retirement, I think that the most fundamental duty of the state should have been to make the education compulsory up to class 10 and then leave everyone to choose his course in future. Second was universal health for every citizen of this country. When we became free, our population was 37 crores. We could afford. There was no problem about it. There was no problem of economics. But we did not think. And what we see today, corporatization of the public health. Of course, recent times the governments of various states have started implementing the scheme of free health facilities for every citizen. It is good. But what I find that in 1950 if we had done, perhaps we would not have seen the scenario today. About dignity of women. about dignity of tribal. It is very easy to debate the subject for hours together and days together. But look at the dignity, what is being done with the female members of our society across the nation. Manipur, latest example, is illuminating. And it happens every day in every city. And nobody is bothered about that. We talk on the TVs, we have debates, but nobody does real thing. So is the position of the tribals, so is the position of the farmers. I will share with you, government has announced compensation to farmers, and media as it is today talks loudly about the government spending on farmers. But perhaps you are not aware, nobody talks of the government waiving 10 lakh crores of loans which have become bad loans given to the industries. That is the public money. Today we talk of parali burning so far as Delhi is concerned, Chandigarh is concerned, Punjab is concerned, Haryana is concerned. But all are ill-informed that Punjab farmers who are having holding of 2 to 4 acres do not have means except to burn parali. Another thing which you must pay attention to while reading the constitution and understanding the plight of the people of the country with reference to their dignity, must have heard about, of course, Mahatma Gandhi talked in for many decades about eradicating altogether this system of sewage workers. In my childhood, Justice Thakker in his childhood and Brother Justice Shah in his childhood must have seen people carrying filth on their heads. We have made some improvement. But even today, every 1 month, every 2 months, 3 months, and recently it happened in Gujarat itself, sewage workers, we have contracted, we have devised the system from 1990 onwards, giving everything on contract. Under the rules of the municipalities, the contractors are bound to provide protective gears to the workers who go in the sewer to clean it. But none does it. The result is every 1 month, some or other sewer worker dies due to poisonous gases. What is the meaning of dignity of people, dignity of individual? Another facet you consider, prisoners. They languish in jails for 12 years, 15 years, 20 years, and then they are acquitted by the Supreme Court. Can anybody think of retrieving those years? And I give you one example which I had seen personally. There was a young girl aged 19 years in Andhra Pradesh. She had sent a letter to the High Court that I was granted bail in a case by the trial court on the condition of furnishing 2 sureties of rupees 5,000 each. I did not have means, and therefore I could not furnish sureties, and therefore after grant of bail I am still in prison for 6 months and chained with a bed. What was her crime? You will be appalled to hear about it. Some people who were armed, called Maoists, they had entered the village. They entered her house in the night, demanded her to cook the food and serve them. With armed people, 10, 15 people coming, nobody could dare not to do that. So she cooked the food. Police said that you are a supporter of Maoist and therefore you are arrested. When the matter came to the High Court, obviously the High Court took suo motu cognizance, issued notice, and when the further investigation was done, it was found that 397 persons who had been granted regular bail by the competent court were not released because of their inability to provide surety of 5,000 to 10,000 rupees. This is the measure of dignity in India after 75 years of independence. I have knowledge about only one state. It must be the situation prevailing across the nation. Therefore, As a small student of law, I would request you to read the Constitution, reach out to the people to ensure that they are not only able to demonstrate and enforce their rights, but also ensure that other people are able to discharge their duties to the society. One small thing I would like to add, we are talking today every day about CSR. CSR is a concept from foreign countries brought by the government of Narasimha Rao, where Dr. Manmohan Singh was the finance minister. He thought that this is a big thing which is being done in the country. As my elder brother Justice Thakker would know, brother Justice Shah would know, CSR used to be a part of our culture in every household. The first bread, roti, which is cooked in our household, goes to feeding some animal or some human being. That is the concept of CSR. And I would like to share before I close a story which I had heard, and of course, I still remember at the age of 6 years, we heard a story from a small vendor, परचून करने वाले. He used to say, ask a question to us. If your income is ₹1, at that time, ₹1 was not the idea, it was Anna. So he said, if your income is 16 Annas, what would you do? How would you spend? People were flabbergasted. We did not know what is the answer. Then we asked him, what is the answer? He said, 4 Anna you spend for today. 4 Anna you keep reserve for tomorrow. 4 Anna you spend for yesterday. And 4 Anna throw in the bell. Again we were bewildered. What is the meaning? Then he explained. And that is an explanation which I am giving to you to understand your responsibility towards the society, to the family. He said, 1/4 of your income should go to daily routine family business, family affairs. 1/4 should go to your elders, your parents and grandparents. 1/4 you save for your children, for their education, for their marriage, and other liabilities, clearing other liabilities. Still, the problem was why 1/4 should be thrown in the well. And the best explanation given by him was that this 1/4 does not belong to you. It belongs to the society. Give it back. That is the idea of our society in India. Give it back. Whosoever is capable, whosoever makes so much of earning, must repay to the society. That is not a donation. That is simply your liability you are discharging as a human being. Thank you very much, Iranshi and your group, for giving me this opportunity to be with you and to, of course, hear my elder brother and the younger brother also. Thank you very much.
Thank you very much, sir, for sharing your experience with us. Now, I would like to again invite Dr. Gururaj to introduce Honorable Justice M.R. Shah, former Judge Supreme Court of India and the patron of Sambhav Initiative, who may deliver a few words about today's event. Over to you, Dr. Giriraj.
Thank you, Chitayu. I am privileged to introduce Honorable Justice M.R. Shah, sir. He is a former judge of the Supreme Court of India, former Chief Justice of the Patna High Court, and a former judge of the Gujarat High Court. He was enrolled as an advocate on 19th July 1982 and practiced in the Gujarat High Court and Central Administrative Tribunal. He was appointed as an additional judge of the Gujarat High Court on 7th March 2004 and appointed as a permanent judge on 22nd June 2005. He was appointed as the Chief Justice of the Patna High Court on 12th August 2018. He was appointed as a judge of the Supreme Court of India on 2nd November 2018. He retired on 15th May 2023, and he has written more than 700 judgments in 4 years, and he has been a part of several high-profile cases. We are honored to have you, sir. Over to you, Justice M.R. Shah, sir.
नमस्कार. Honorable Mr. Justice C.K. Thakker, former Judge Supreme Court of India, and my Guru, Honorable Mr. Justice G.S. Singhvi, former Judge Supreme Court of India. Again, I can say that he is also my Guru when he was here in Gujarat. Shah, the members of the Sambhav initiative, and all participants. First of all, I congratulate Iransi and other members of the Sambhav initiative for organizing and celebrating We the People Week 2023 and celebrating in a week संविधान से संवाद तक on different aspects and touching the Constitution of India. I am also thankful to Iransi for giving me this opportunity to be present and participate in the event. The Constitution of India is created by the people of India and for the people of India, as emphasized in preamble by the phrase, we, the people of India. The preamble of the Constitution itself sets a tone of introduction to a document, highlighting the principles of and fundamental values of the document. The articles and the provisions therein promise to ensure justice, liberty, equality, and fraternity to the people of India. I do not much deliberate on the preamble, as the same is already discussed in detail by Justice G.S. Singhvi. The Constitution of India provides for various rights such as rights of citizenship, right to equality, etc. The first Constitution amendment was in the year 1951 and the last amendment was in 2021. So, between 1951 to 2021, the Constitution has been amended 105 times. The right to education is provided in the Constitution after a long, after passing of number of years. As rightly said by Justice Singhvi, it is very unfortunate that the right to education was given a color of fundamental right after a number of years. Better late than never. Now let us understand what is the Constitution of India. During the earlier years of the constitutional development, the Constitution of India was viewed as a political document which granted civil and political rights that citizens lacked under the colonial regime. Gradually, the Constitution came to be understood as a social document premised on the principles of equity and fairness. This expansion of the understanding of the constitutional values broadens the role of the courts in our constitution democracy. The Constitution provides for the fundamental rights as well as the fundamental duties. Fundamental rights and fundamental duties are most important features guaranteed by the Constitution of India. Our certain fundamental rights are not absolute and they can be subject to certain restrictions. Thus, fundamental rights and the fundamental duties as such can be said to be two sides of the same coin to maintain the rule of law and good governance. Now the question is whether the citizens, when insist for their fundamental rights, do they think about the fundamental duties? Everybody talks about the fundamental rights, but not about the fundamental duties. Fundamental rights as such cannot be enjoyed at the cost of increasing the rights of the others. When we talk about freedom of speech, we can enjoy the freedom of speech at the cost of, we cannot enjoy the freedom of speech at the cost of dignity of others. By the preamble, the Constitution secures to all citizens liberty of thought, expression, belief, faith, and worship. These are fundamental rights of the citizens, but this is the only sentence in the whole preamble which enumerates the rights. Rest of the preamble emphasizes on the duties. Thus, when we talk about infringement of fundamental rights, which we shall also think about fundamental duties which we owe to the society and the nation. So, by the protection of fundamental rights are concerned, guaranteed the Constitution of India are concerned, most important fundamental rights are right to privacy, right to information, right to equality, freedom of speech, freedom of expression, freedom of religion, and most importantly, the right to constitutional remedies. Let us talk about the right to constitutional remedies. Article 32 of the Constitution of India provides for remedies for enforcement of rights conferred by Part 3 of the Constitution. Any citizen who alleges infringement of rights conferred by Part 3 of the Constitution, infringement and or violation of the fundamental rights, may have the legal remedy by approaching the court of law, including the High Court and the Supreme Court. Public interest petitions are the most important rights which are available to the citizen and the common man. Anybody who is suffering from the infringement and violation of the fundamental rights may even write a postcard to the court, and the same is treated as suo motu writ petitions, which is the most important thing provided by the Constitution of India. Now, let us understand the necessity for fundamental rights. The necessity for fundamental rights in India emerged from the heinous experiences under the colonial British regime. Framers of the Constitution, while pondering over the fundamental rights, were of the view that every human should have access to basic needs, dignity, and equality that will be absolute and cannot be taken away by state. For ages, India has been divided based on gender, caste, and religion. There is a little bit improvement, but yet we have to achieve the result, ultimate goal which is provided under the Constitution of India. Equality before the law and equal protection of laws for every citizen is ensured by Article 14 of the Constitution of India. Every citizen is protected against an individual and against a tyrannical will of the state. As discussed above, the rights and duties go hand in hand. However, it is the interpretation of duties that plays a crucial role in society like India. Mahatma Gandhi in Swaraj has stated that unless you perform your fundamental duties provided by the Constitution of India, you cannot enjoy the fundamental rights also. So it is the duty of everybody to see that they also perform the fundamental rights while asking for the fundamental duties. Now let us consider one thing, that whether are we performing our fundamental duties provided under the Constitution of India. This is the culture, and it is unfortunate that in today's everybody is concerned, why should I bother? Why should I do? Let others do. That is the most unfortunate thing which is happening in today's scenario. We are doing that because we are not affected by ourselves. You are not doing because you are not affected yourself. If you don't help bring about justice, then one day you too may have experienced injustice, and there will be nobody to stand before you and by you. It is about standing up for each other, which the Sambhav initiative is fortunately doing it. Every day an injustice is happening. It is our duty to be there for others, to speak up for others when they cannot. You should know the power of yourself and your voice to stand up for what is right and what is wrong. Sambhav initiative is doing extremely well to protect the rights of the others, and they are standing up for the cause of the others. Iransi and his team and her team deserves compliment. Let us now pray to the God to strengthen us to maintain the rule of law and maintain the constitutionalism and preserve our constitution and the constitutional rights. Let us all take oath today to preserve the constitution, more particularly the fundamental rights and the fundamental duties provided under the Constitution of India. Let us all be a good citizen and act as per the Constitution and maintain the high values in the life and let live all with human dignity. Iransi, I am thankful to you and all your colleagues for giving me this opportunity. I am also thankful to Honorable Justice C.K. Thakker, my Guru, and Honorable Justice G.S. Singhvi for their valuable thoughts, which I will also try to implement and digest. Thank you very much. Jai Hind,
Thank you.
Bharat Mata ki Jai.
Sir. Thank you so much, sir.
Thank you very much, sir, for sharing your experience. Now, I would like to again invite Dr. Gururaj to introduce Honorable Tushar Mehta, sir, Solicitor General of India, who has sent his recorded video due to
I'm privileged to introduce Shri Tushar Mehta, sir. He's a senior counsel in India and is currently serving as the Solicitor General of India. He attended the Gujarat University where he obtained his law degree and received 5 gold medals. He has also received honorary doctorate degree from MIT University, Noida, and the Karnataka State Law University. He began his career as an advocate in the year 1987 and was designated as a senior advocate in 2007 at the age of 42 by the Gujarat High Court. He was appointed as the additional Advocate General in the year 2008. He was appointed as the Additional Solicitor General of India in 2014. Sir was then appointed as the Solicitor General of India in 2018. Now, I would request the technical team of the Sambhav initiative to play the video sent by Shri Tushar Mehta, sir.
I would just like to mention one thing that due to the extension of the prior event of Sir at the Ministry of Law and Justice, Government of India, he has been unable to join us, but we are fortunate enough to have his video with us. So I would request the technical team to kindly share the screen and play the video.
Honorable Justice Singhvi sir, Honorable Justice Thakker sir, Honorable Justice M.R. Shah sir, Hiranshi Shah, Devanshi Agarwal, and friends. Today is a historic day. The Constitution from its very outset was meant to be a document that could withstand the test of time. It was to be, in the words of interim assembly, and especially the president of the interim assembly, Sachidanand Sinha, a document of
adamantine strength. The Constitution was not conceived as simply a legal text or a set of rules for governance. It was supposed to be manifestation of the very spirit of Indian people. It was coming together of disparate groups into a cohesive society and nation as a whole. When the Constituent Assembly set forth on the constitution making, the process faced several complex challenges, inasmuch as about 2/3 of India's future territory lay outside its legal jurisdiction. Very few people highlight this aspect, but our founding fathers of the Constitution have beautifully tackled this challenge. At the time when Constituent Assembly was constituting the Constitution of India, more than approximately 550 princely states were spread throughout the length and breadth in the subcontinent, which covered about 45% of its territory and had a population of nearly 93 million at that point of time. And they were not part of Union of India. Many of the states were in the process of framing their own constitution, which was permitted by the Indian Independence Act. And the Constituent Assembly had no power of framing any constitution for that particular territory. The making of Indian Constitution thus entailed assembling the constitutions of each of the princely states into what I call future constitutional order. In fact, diverse publics across the country read and deliberated on the anticipated constitution in the range of sites, including darbars, that is, the courts of the former princely states, in judges' chambers, and even in tribal villages in deep forests. One of the common criticism of the Constitution is that it had been drafted by lawyers and for lawyers. It is a criticism of which the Assembly, even at the time of drafting, was aware. Once in the Assembly, they are discussing the concept of citizenship and how the Constitution must deal with the question of citizenship. One eminent member, R.V. Dhulekar, says that he wants the question considered by the committee, to which Pandit Nehru responded that this is for the chair to decide. The chairman says he would want the lawyers to examine the citizenship clauses. To this, the eminent, the great Pattabhi Sitaramaiah said, I suggest that in addition to 3 lawyers, 1 man of common sense may also be added. It was a little sarcastic remark that lawyers need not always have a common sense, but it went as one of the most significant part of history, since apart from the lawyers, a common man was also requested to be added. The chairman responded, I do not exclude lawyers from the category of people with common sense. Most democracies and their constitutions, especially those democracies where they got the independence simultaneously with our country, remain short-lived. We have the experience of our neighbors. Unlike in so many other Asian and African countries where constitutions at the time of decolonization was largely what is called a parting gift of the colonial rulers, the Britishers, India is one of the few countries which developed and wrote its own constitution for itself, keeping in mind the socio-economic conditions and several other factors with a view to ensure that the constitution, when it comes into effect, functions as a living document and withstand the challenges of time. Friends, India is a symphony where there are as in an orchestra, different instruments, each with its particular sonority, each with its distinct sound, all combining to interpret one particular score. It is this kind of combination that this country always stood for. If we therefore stand out for the great ideal for which this country had stood, the ideal which has survived the assaults of invaders since centuries, the ideals to which the unheeding world today is turning its attention, if we are able to do it, the flame which has sustained us in overcoming foreign rule will fire our efforts to build a united and free India. While there may be various lacunae that need to be filled up and multiple provisions perhaps were sharpened in our constitutional history, it has undoubtedly over 70 plus years survived the struggle against several odds and has played a key role in sustaining this largest democracy of the world. Friends, I always say our constitution is resilient. It withers all challenges, even the worst challenges under which normal circumstances the constitution would break. A very interesting incident once during the emergency where the constitution itself was under a very serious jeopardy. The then opposition leader and a leader of eminence, Acharya Kripalani, was hospitalized. The doctors who came to check told him that he is suffering from poor constitution. Kripalani replied, "I have no constitution, I have only amendments." He was being sarcastic, of course, but it reflected the mood of the time. How everyone felt the constitution wouldn't recover from the emergency, and yet, even from that terrible period, the constitution not only withstood the challenge, but it emerged stronger. The constitution is carefully molded to be a responsive document, which can only meet the challenges of the time in which it was created, but the challenges of the future as well. The responsiveness and forethought is at the heart of several of the Constitution's features. The fundamental rights are the foremost example. This is future-oriented approach undertaken by our stalwarts who drafted the Constitution. They drafted only one line article, namely Article 21, and several rights could flow from that one line article. Livelihood, shelter, legal aid, health, all have become part of Article 21 progressively. Thus, the symphony, which initially was envisaged by Dr. Radhakrishnan, has only grown more melodious and beautiful with time. India's constitution making was not limited to shaping a new political document, but was intended to transform the social and economic life of its people post-decolonization. In this, the Constitution has fulfilled not only the goal of keeping up with times, but of being a vehicle of change for the betterment of India's citizens. Whether it is the charting of new frontiers of privacy rights in K.S. Puttuswamy, the protection of rights of Muslim women in Shaira Banu, or any other document, any other judicial pronouncement, it is only and only the foresight of the framers of the Constitution which has helped, assisted the court to evolve new doctrines and new order. Friends, I am thankful to Sambhav Initiative that I am given this opportunity to interact with you. It's indeed a privilege and a pleasure to share any platform with luminaries like Justice Singhvi, Justice Thakker, and Justice Shah. Thank you so much, and a very good evening to all of you.
We are extremely grateful to Shri Tushar Mehta sir for enlightening us with his recorded message on today's occasion. Now, I would like to invite Advocate on Record, Supreme Court of India, Ms. Pallavi Pratap, the expert board member of Sambhav Initiative, to deliver the concluding remarks for today's event.
Thank you so much, Jitayu, for that. And I'm just so grateful to Sambhav Initiative and Hiranshi for having me on board. And also today to be listening the legal luminaries like Justice Thakker, Justice Singhvi, and Justice Shah today, and also the learned SG. What I would actually want to start off with is with Justice Thakker's word, where he said that king can do no wrong. And then we saw how he mentioned specifically about the part 3 of the Constitution. I think today all of us have understood how important the part 3 is, and especially the focus that he had on the directive principles of state policy. Moving on, then Justice Singhvi enlightened us with the specific reason as to why terms like scheduled caste, scheduled tribe, and backward classes are used, and also how he spoke about it is the importance of
Yes.
Sorry. And also the importance of the challenges rather that the Constitution is facing. As a matter of fact, while we were discussing, I was also going through an article in Bar and Bench where somebody has come up with the idea of having a new constitution altogether, since it has become old after 7 decades. I'm surprised that such thoughts and ideas are also coming up when we can see that we have a very effective constitution. It's just that it just like a young country, it needs to evolve with time. Moving on to Justice Shah, and the fact that he mentioned that we, as citizens, we are always talking about fundamental rights, and we completely ignore that there are fundamental duties that we have to live up to. I think that's important for all of us as law students also, to look at that there are duties that are there, and to ensure that we are able to preserve the Constitution. The learned SG mentioned about the beautiful evolution of the Constitution, and he took us through very interesting anecdotes about the Constituent Assembly. I think we've had a great learning session today, and I wish all the best to Ranshi and everybody here for bringing about this beautiful initiative. And thank you so much, Justice Thakker, Justice Singhvi, and Justice Shah for giving us the most enlightening 1 hour of your time, and taking us through the Constitution in no manner that we could have easily learned. Thank you so much.
Thank you very much, ma'am.
Thank you. Thank you.
Thank you very much, Ms. Pallavi Pratap ma'am, for the concluding remarks. Now, I would like to invite Ms. Hiranshi Shah ma'am to deliver the vote of thanks for today's event.
Thank you, Jatayu. With the honorable dignitaries, team members, and other ladies and gentlemen presented here, it gave me immense pleasure to extend my sincere thanks firstly towards to Justice C.K. Thakker sir, Patron-in-Chief of Sambhav Initiative, and Justice Emma Shah sir, former Judge of Supreme Court of India and the Patron of Sambhav Initiative, for their always provide invaluable advice and support to the Sambhav Initiative by today, which we are going to be able organize this week. And also on behalf of the Sambhav Initiative, I would like to express my sincere gratitude to Justice Singhvi sir, former Judge of Supreme Court of India, for accepting our invitation and for sharing your valuable words with us, sir. On behalf of the Sambhav Initiative, I would also express my sincere gratitude to Shri Tushar Mehta sir, Solicitor General of India, for sending this amazing video, being inspired that unable to attend due to some prior ongoing event. I also would like to thanks to other dignitaries, other board members of Sambhav Initiative, and all the attendees for giving your valuable time to join us on this occasion. And last but not least, I also express my gratitude to the team members of the Sambhav Initiative, that is Jayan, Jatayu, Devanshi, and also the technical team, Tanmay, Sahil, and Sashank, for your outstanding work. Thank you, everyone.
Thank you
for joining us on this occasion.
Thank you. Thank you.
Thank you everyone for joining and making this possible.
Thank
Have a
you,
great day
Justice
ahead.
Thakker. Thank you, Justice Shah, and thank all participants.
Good to
Thank
see you.
you.
थैंक यू साहब, थैंक यू।
हाँ जी,
दिल्ली आए तो याद रखिएगा।
हाँ जी, जरूर सर, जरूर।
Just before we would like to acknowledge the presence of Dr. Ashok Kumar Joshi sir, who has joined us. Thank you very much, sir, for joining our event.
Thank you all for joining us. Thank you. Host, please end the meeting.